My name is John Lawford. I'm the Executive Director at the Public Interest Advocacy Centre, and I've been very pleased to be invited to introduce this panel on privacy after death. I'm not going to go into a long explanation of each of the speakers' biographies, which are in your materials. I'll just mention a little bit about each of them. Mistral Goudreau, as you probably all in the room know, is a professor at the University of Ottawa and is an expert in IP law and is here doing something a little bit new for her in talking about privacy and death, but she's up for the challenge. To her left is Margaret Ann Wilkinson, and she is a professor at the University of Western Ontario Law Faculty, and she has written a book on genealogy and the law in Canada. Beside her is Julia Crete, who is an associate professor at York University and also a filmmaker who is going to entertain you with some of her work, documentary work. I'm going to freestyle a little bit and grab a little bit of their time just to mention a few facts that might help you in thinking about this issue. I'm a lawyer and a common lawyer and a consumer advocate, so I'm going to point out a couple things about the law that have always interested me in this area. And one is that at common law, when you die, all your personal actions die with you. And the case that's about that is called the America. It was about a ship. And in 1917, House of Lords made that decision and said you cannot sue for personal torts after someone has died. And from that time on, we had things like Fatal Accidents Acts and dependents legislation so that people would not be totally destitute if there was a wrongful death. The second thing you should know is that in PIPEDA, in section 7, sub 3, sub H, there is curiously a continuation of privacy under that legislation for 100 years after the record is created or 20 years after the person who is the subject of it dies, whichever is earlier. So in other words, we have legislated a little bit of temporary power to control personal information after death here in Canada under that statute. So this is in part what we'll be reacting to on this panel. But first I'm going to invite Mistral to come up and speak first.
Alors bonjour, je vais vous présenter.
Hello everyone, I'd like to talk to you about privacy after death, and the presentation that I'm going to make to you this afternoon starts with the following paradox. The first privacy law that was recognized, which was in 1858 for the publication of the portrait of Isabelle Rachel Felix, who had died. The family had taken a photo of her, and it was to be painted as a portrait by a painter and then distributed in the newspapers. The family took action, and they were able to stop the publishing of this portrait in the newspapers. It's ironic because this is the first case where privacy is recognized. Today, however, privacy and the right to privacy cannot be passed on to heirs. It stops after death, basically. It's something that is enshrined, as my colleague John has already explained, but it's also enshrined in civil law through jurisprudence and also by Parliament. In Quebec, it's covered by Section 35. Now, for civil law, it cannot be divided into various torts. There's no notion of defamation, of publicity right, or of an intrusion on seclusion. It's a whole, and you can see this under 35 and 36, that is part of a whole, and there are limits. The right for the public to know must be applied. So there are exceptions to privacy that has to be determined on a case-by-case basis. The legislature in 1994 in Quebec had planned for the privacy to be transmissible because it said that Article 35 could not violate the privacy of a person without the consent of that person or the consent of a person's heirs. In 2002, in the wake of pressure brought to bear by journalists, the words "or heirs" was struck out, and the legislature changed its decision. It reviewed its decision, and it recognized at that point that privacy cannot be passed on to heirs. It's ironic because today, dead people tend to survive in our memories longer. We have the technology we need now to even interact with dead people. You remember perhaps the duo Elvis Presley and Celine Dion, for example, or even members of the public who were asked to record songs sung by Elvis Presley and by a living person. This is ironic because increasingly, basically, we're seeing that dead people continue to survive much longer in our memories. We're even able to bring their memories back to life. The other irony really is that there are several exceptions to the rule of not being able to pass on privacy rights. Well, there's copyright, for example. This is perpetual in France. It has no end. In Canada, of course, it is in force for up to 50 years after the death of a person. It's used to protect a person's privacy. There are examples here where it was used to stop the publication of interviews given by a deceased person. In Canada, this was something that was not accepted in Gold State against Stoddard. Now, this protection through copyright can have an impact on the way we think about history, the way we present history. There's an example in 2015, for example, Martin Luther King's speeches had to be rewritten because the heirs had already ceded the rights on these speeches and refused to authorize the use of these speeches in a film on Martin Luther King. Second exception, which is the Trademark Act. Once again, there's protection here. You can't use the signature or the picture of someone in the 30 years following their death. Now here, this is a bit different because this right can move. It can move from that person to the company. It can be transferred. Therefore, once the consent's been obtained, it can build the reputation on the name. Now, this transfer and the use of a person's name in a trademark is something that cannot be changed. It's permanent. However, in Quebec, it was decided that the heirs of a deceased singer, for example, could oppose or could stop a jazz comp using that person's name after their death. So we can see that protections are not always under privacy laws. Sometimes they come under commercial law, trade law, passing off rules or rules governing unfair competition. So the length of protection is undefined. It's indefinite. So in terms of passing off, you have to prove that there's been a direct desire to pull the wool over people's eyes. If there's a picture on a T-shirt, does that lead the public to think that the artist and the heirs of that artist could given their consent and have actually accepted this? So this is much broader. It's much broader than under privacy laws, especially as they exist in Quebec. In Quebec, well, there are two decisions. There are two decisions which recognize privacy post-mortem. The right to control the use of a person's name or an entertainment right on specific characteristics of an actor, let's say. So Quebec legislation is pretty close to the publicity right that exists in the U.S. Now, the publicity right in American law is recognized as a property right. Some states have made it so it cannot be passed on. Some allow it to be passed on. Now, the American restatement now states that the publicity right is not covered by the right to pass on. Now, this is public. If you want to use this publicity right, you have to have used it during your lifetime. In a recent case, 2012, an American court has said that the publicity right should stop 50 years after the death of the person. There was no legislative support on the duration. Now, in France, there are also problems. Should the survival of a right for the property aspects of a person's life. If I've used my name, my image, for example, should this continue after my death? Some decisions in Quebec say yes. If there's an economic interest here, it should survive a person's death, and the heirs would control this right. There's the Beaton-Corbusier case, for example. And in Quebec legislation, the right to compensation in punitive damages for a violation of a fundamental right, it cannot be passed on. The right to privacy is recognized under Section 5 of the Quebec Charter. If a fundamental or basic right is violated and leads to punitive damages, this cannot be passed on. So perhaps privacy also. So we can see that the majority of authors don't support this position. We see that there are opportunities really for some parts of privacy to continue after death. Now, there's a distinction here between there's property and not property. That's going to be difficult to make a distinction. A Twitter account, is that part of my personal life? Is it part of my personal property? Or if I send emails of my company's clients to my friends, is that of value? Is it something that can be passed on? Now, in Quebec, it cannot be passed on. Privacy rights cannot be passed on, except for moral rights, except for trademarks, except if there's confusion, and except if it's something to do with a person's personal property. Now, this brings me to the final point I'd like to make here. What about people's loved ones? Well, privacy law, or privacy really stops with the death of a person, but the heirs of this person would be harmed if information on their loved one is disclosed. In the Rachel case, this is what happened. The image of a person on their deathbed, well, if the people close to that person actually see this image, they're going to feel pain. Now, what does this require? It requires violation of the dignity of death, the respect that we deserve dead people, etc. There are examples here. Well, there's the photo of the deceased person who had been tortured and whose photo had been sent to the family for a ransom. If this photo is published widely, it's harm to the family. But personal information on the state of the health of François Mitterrand, for example, the French president, if this information is disclosed, well, the court has said, well, you can stop the disclosure in the days following the death of the president, but not a year later. And this is the latest decision by the Human Rights Court in France. Freedom of speech takes primacy 10 months after the death of the president, and the state of health of the president before he died can be disclosed. Now, this brings me to the specific issue, the right of people close to the deceased person. This is something that's recognized in civil law. It's a negative right, the right to stop the disclosure of information, but there's no there's no right to have access to information, or almost none. Accessing information, well, I can do that if I'm dealing with a will, for example, if I want to make a claim on a life insurance policy, for example, of the dead person, if I want to resolve legal disputes, but I don't have the right to get other information. And now, in Quebec's case law, the Privacy Commission has refused to allow families to have access to information. In the case of suicide, the information has been refused about the possible birth of half-sisters or half-brothers. And people were asking for access to the medical files of their mother to see whether half-sisters or half-brothers had been born. This information was not allowed. It's not stated in the law that loved ones or family have access to that information. So it's a purely negative right to stop the disclosure of information. It never allows for access to information except in limited cases. Now, this is a right which is now being challenged. The rights which are not being awarded to families are now being challenged. It's being challenged by the European Court of Human Rights. It's been recognized that a descendant did have a right to protect the memory of their ascendants. But of course, this is limited. But in both cases that I've just mentioned, the courts state that the descendants of these people can take steps to protect themselves, protect the reputation of the deceased. And now, in international law, people have the right to their origins. Now, very often these origins I'd like to quote the articles of one of my colleagues from the Civil Law Department on the right to know about one's origins. Now, this right stops at knowing the name of the person who gave birth to you, for example, and quite probably would give you access to only general information about that person who is now deceased. So the current privacy laws should be challenged because privacy isn't just about protecting your privacy while you're alive, but also as part of a family, as part of a community, who perhaps means that privacy laws should be reviewed. Thanks very much. I'd like to thank you for having invited me to speak, and I'd like to leave you on that now.
So for a little change of pace, I want to turn to something that fits in with some of the themes that we've been talking about earlier about social norms and looking again about first principles and how they're applying. And I want to turn your attention to the fast-growing hobby and pursuit, actually, in a commercial context of genealogy. Now, I don't know how many people in the room here have already actively started to become genealogists, but I can probably make a pretty good prediction that very large numbers of this audience will become genealogists. It is a fascinating and fast-growing activity that is evidence-based, that follows a certain logic, that has all the elements of history in it, and of course is highly, highly personal. For this reason, I became very interested in it a number of years ago because its expectations and norms run counter to a lot of what has been happening in terms of increasing protection of personal data and in other areas. So I just want to take the opportunity to share 3 areas with you, just a couple of comments about its intersections with many areas of law that governs information. And then I want to turn to look specifically at personal data protection in terms of genealogists' access to information. And then I want to finish off with a couple of comments about the increasing, or some thoughts about turning our attention to the increasing prevalence of genealogy as a major activity, not just a leisure activity, but many people are becoming very, very concerned about this on an international level. So it is one of Canada's fastest growing interests and pastimes. I spend a lot of time with my colleagues in library and information science, and I know that it is the most rapidly growing use of local information resources right across Canada in every public library. But so that's to kind of speak to you in a minute about the increasing demand of genealogists on institutions that are responsible for personal data protection. Also, the other thing that is interesting about it is that genealogists have almost a reverse impression of privacy. And as I'll say again later, for a genealogist, the notion that your personal privacy is concerned only with your own person is almost an irrelevance to them. They typically consider that they know a lot about themselves. What they're looking for is what they see as their ownership in their family. So they have a much wider concept of their personal identity that goes quite beyond themselves and moves into their family. In terms of the law that impacts genealogists, and again, this is a growing matter, originally 30 years ago, genealogy was largely a hobby and often a retirement hobby. But of course, once you get good at doing your own genealogy and you get a little bit ahead and you've got some information to share, it's quite typically now moving into the arena where you're actually conducting a little business, doing genealogy for other people and sharing your knowledge. Frequently for the genealogists that I've run into, that shift from it being a hobby and a use of personal research to that shift where you view yourself still doing personal research, but you might need to be compensated a little bit because you're using a bit of expertise. So the shift into a business is not always noticed, and it does have an impact on the effect of personal data protection on the work that you're doing. So genealogists typically have two different intersections with the law. The first one is who controls access to the information that a genealogist is seeking about a family or individual. And they're always thinking about an individual in the context of family. So, as a law professor, I am likely to say a family or individual. A practicing genealogist will always say an individual in family. They don't actually make that distinction between the individual and the individual's family. The other area that genealogists are very concerned about is who controls the information about a family tree that they have pulled together. And that there's an increasing concern amongst genealogists about this, perhaps not for the reasons that you and I would think in terms of personal data protection, but one of their major concerns at a national and international level is preventing the spread of misinformation. And of course, any genealogy that doesn't agree with your genealogy is clearly misinformation. So there has to be some way of dealing with this. So I'm going to turn to that second aspect just for a moment to indicate the different areas of law that a genealogist will be interested in. And in this connection, personal data protection does govern the professional genealogist's activities, which is something that is challenging for a genealogist in making the shift from hobby to professional genealogist. And then the other area where genealogists more frequently understand that they're getting into trouble or do get into trouble is, of course, they've been using exceptions to gather or users' rights, as they are known in Canada, for copyright in terms of research and private study. But when they go to disseminate their product, and the products are becoming, more and more large-scale publications with photographs, charts, full documents and so on, they're getting into trouble with with copyright. And then, as I said, they have a real concern about controlling what they perceive as misinformation. And in this area, the law available to them doesn't provide them with the tools that they believe they need in order to keep the genealogical record clear and appropriate. But I want to come back and focus on the first aspect of their work, which is getting access to the information for purposes of our conversation here. And they're involved both with privacy law and personal data protection in this area. From their perspective, generally, these areas of law create barriers to their mission, which is to essentially discover about themselves their full family background. So keeping in mind that for the genealogy, the self isn't just the self, the individual, but it's the family identity in the self that is important. On the one hand, the access aspects of personal data protection across Canada has actually helped them, because about themselves, they will have access to more information more reliably than they did before, but that's actually not the information that they're so excited about, so they are very keenly disappointed, and have been very keenly disappointed for a quarter century, that personal data protection makes no allowance for their right to access information about their family. And they also are surprised when approaching their family that sometimes their family doesn't want to gather information for them and then contribute to their tree. Now, one of the things that can be said about the hobby is, well, as we've just been talking about, the barrier is, the life of the individual plus a certain number of years depending on the jurisdiction. In Ontario, typically, it is 30 years afterwards, and I'm going to use some Ontario examples later. And so you say, well, but then behind that date, so after that date, you have full access to the historic record, even though it contains personal data protection. So what are you, the genealogist, complaining about? Well, as I mentioned at the outset, genealogy is very, very evidence-based. So the problem is that with only your own information accessible to you during the lifetime of your family members, and a gap between the lifetime of your family members plus, let's say, 30 years, you can't reliably access the documents that then connect you to the appropriate branches of the historical record beyond that. And people find that very, very frustrating in what they're doing. The other practical problem that genealogists are running into, especially since the advent of PIPEDA in the private sector, is private sector organizations have now become seriously sensitized to the value of personal data. And what's happening, of course, in the private sector, there's no compensating access requirement once the personal data protection expires. So private companies and organizations who used to make available archival records, now having become sensitized, are either just not putting out the effort to make any further inquiry and basically declare that some material can become accessible once the personal data protection barrier has expired, or they're just getting rid of the records when there's no reason to keep them any longer. And this is extremely frustrating to genealogists. So I want to turn to the third point that I wanted to make, and this is just so that I've given you two areas where the genealogists are frustrated by the personal data protection legislation as it exists now. I want to turn now a little bit to the impact that may occur because of the rapid increase of this hobby. And there's a whole lot of other things that we can talk about, because the hobby obviously has international dimensions and doesn't stay just within our jurisdictions. But just within our jurisdictions, one of the things about the way personal data protection is currently legislated is it is data item specific. So I just pick an example of an Ontario order from the Privacy Commissioner's office. And in this case, the request, and it was actually from a professional genealogist, not that it matters to the outcome at all, but it was to go behind the marriage and death certificates to the records that created the marriage and death certificates. And the point of this slide basically is that the decision decided that every single record had to be examined to see exactly what particles of personal data existed on these background documents to the marriage and death certificates, and they couldn't be treated as classes of records. So that you see on the one side a whole list of data items within a record that would be disclosed on the left, and on the right, a number of items, if they were present in a record, would have to be excised before the document could be released. And my point here is that this way of looking at the data is extremely labor intensive, and at some level, genealogy, although it is a real passion for people, it is a hobby. So we have a lot of organizations that are subject to personal data protection requirements doing a lot of work here at an individual data level within a record that may not be that important at a certain point. On the other hand, there was another example also from Ontario in an order, and this took a different approach, and I work a lot again with librarians and archivists, so this order takes a very archival approach, and it's something to think about. This order essentially looks at the record as a class, or a fond, as you would say in archival science. So the request here was for all the information about school classes at the Port Stanley Public School. It's a request that endears itself to my heart because Port Stanley is 20 minutes from London. And they wanted the records from 1899 to 1964. And they weren't actually interested in the full attendance record. But what they wanted the information for was, as you can imagine, the teacher's name and the class members' names of everybody that was in this school for a number of years. And of course, the problem is that the data couldn't be released unless people had been dead for 30 years. So what I quite like from an archival point of view about this order, and there are a number of other orders that have followed this way of doing things, but in order to make classes of records that could be released by the school board, they basically said, well, rather than going for the individuals that are listed on these class records and trying to figure out if they're alive or dead, which tends to be the copyright approach, let's look at the Statistics Canada lifespan expectation of people who would have been in these classes from 1899. So they took, for instance, 1920 to 1922. Stats Canada said men lived 59 years, women lived 61 years. So they took an average of 60 years, which is, again, extrapolating from the Stats Can database and making it even more general, which is interesting. Then they said, let's assume that every child that goes to Port Stanley Public School, and this would be historically, pretty much accurate because the school started in grade 1. So let's assume everybody is 6 years old when they start school. So then they just simply did an overall math and said, okay, we'll take 60 years as the average life, we'll take 30 years beyond that as the statute requires, and then we'll add another 6 years beyond that for everybody starting grade 1, and then as people progress through grade 1 to grade 8, different records at the tail end of this conversation will be available until everybody who was born in 1925 has been through the school system. So then they just made a general order saying, okay, Port Stanley School, it was actually the Thames Valley School District that held the records by this time, you can release all the information here between 1899 and 1925 and be done with it. And that's just going to be our order. So just in terms of going forward, a couple of things to note. The only province that does actually recognize genealogy at all as a hobby or a calling within personal data protection context is Quebec, which has a regulation that deals with genealogy in a very small way. Otherwise, it's not a recognized exception or different class of people. This is, of course, puts Canada out of step with other jurisdictions that aren't so interested in personal data protection. So there's a lot of information about Ontario residents circulating elsewhere. And of course, when you release the data, as a genealogist having found it, the hobbyist genealogist has no responsibility as an organization subject to personal data protection to take any further care, whereas a professional genealogist does have that responsibility. And yet, with this increasing popularity of the hobby, these are only a few samples of orders that are being made that were in instances where the requests are originating from the genealogy hobby. So it is definitely increasing and definitely putting pressure to assert an increase. It's not obviously the most important use of our resources, but it is an increasing use of our resources in pursuit of a hobby, which the public library statistics indicate is only going to get more and more popular as some of us reach the baby boomers reach the retirement years. So thank you very much for that.
Screen, or you want to just?
Yeah, let's go. Well, I'll need it until, actually not, because I'll need, I guess I can still get, yeah, okay, that's great. This one was first, right?
Okay, yeah.
Okay. Right. Don't worry, that'll be clearer once it actually starts. So I want to talk about, well, let me frame this talk a little bit. It's the larger documentary project is called The Need to Know: Ancestry and the Business of Family. And it's a documentary that explores the motivations for genealogy and family history, not just within amateur and expert genealogists, but also through the perspective of industry representatives and researchers. So the reason I'm actually an English professor, so I'm one of the outliers here. But the reason I became interested in this topic is that I had taken my own genealogical journey, and one that really provoked intense and ongoing privacy issues in my family, real disagreement in my family about the kinds of information that I was discovering. And after a while, having been down that rabbit hole for about a decade, I realized that I was part of a much, much wider zeitgeist, which suggested that both my motivations and the issues that that my research sort of unearthed were not individual to me. So I then decided that I should examine the wider industry and its motivations, in part to understand my own. And particularly the question of innateness, the innateness of the need to know where we come from, in the context of this rapid growth of genealogical technologies. Not just these mass international databases, but also direct-to-consumer genetic genealogy, which is one of the fastest growing areas of genealogy is DNA testing. So out of that curiosity came a set of questions about who was accumulating and aggregating genealogical records and biodata, and why they were collecting it, who owned the information, and what the database owners might do with the information in the future. And that's an entirely open-ended question. And privacy concerns, particularly privacy of the dead, naturally followed. So genealogical pursuits seem really relatively benign, yet necessarily involve very, very sensitive information about the living and the dead. So given this widespread popular interest, and it's really, the statistics are really quite interesting, and Stats Canada has tracked the use of genealogical resources in the National Archives, and you can see the spike. It starts to take off in about 1998, and then it just grows exponentially. So given widespread popular interest in genealogy, a documentary seemed the best form of research dissemination, because I think in this case, we really do want to talk to people about what happens to their records and what they're contributing and giving away. So this research was actually funded by SSHRC and the Office of the Privacy Commissioner, and it's the first documentary that the OPC has funded, and so thank you very, very much. I want to tell you a little bit before I screen these clips about where the largest accumulation of genealogical information is, and it's concentrated in Utah, primarily in Salt Lake City and in Provo, and that's a consequence of Mormon doctrine. And I don't know how much you know about the Mormon Project, and we can talk a little bit about that later. I interviewed the top executives from Family Search, which is the Mormon database, which is the largest genealogical database in the world. And it's gathered and owned by the Church of Jesus Christ of the Latter-day Saints, the LDS for short. The founders of Ancestry.com, which is the largest commercial database in the world, and it was started by Mormon entrepreneurs and is now owned by a private equity firm. The CEO of Sorensen Genetics, this is just the research that I did in Salt Lake City. The CEO of Sorensen Genetics, which was a nonprofit genetic genealogy company. They gathered information around the world. They gathered 100,000 braided genealogy and genetic samples on a nonprofit basis, and then they sold that entire database to Ancestry in 2012. Huge issues of the transfer of information with respect to genealogy information. So I asked them all about proprietary rights and privacy. And at the same time, I wondered what individual users of these databases might know about these issues. So I'll show you a few relevant clips from the documentary with respect to issues of ownership of data, a gray area, according to one of the founders of Ancestry, and the aggregation and braiding of genealogical data, specifically with, again, an eye to the rights of the dead. Now, the reason I think that these issues might be of some consequence is because of the case of Iceland. So I spent a fair bit of time in Iceland as well. And Iceland has the world's most complete national genealogy database. And the world's first fully, as far as I know, fully braided database, combining genealogical records, DNA samples, and medical records. The genealogy database was paid for by Decode Genetics, which was a publicly traded genetics research company, which was granted a 12-year license by Iceland's privacy commissioner to use the medical records of the company, or the medical records of the country, to carry out this groundbreaking research on genetically inherited diseases. Unfortunately, the company went bankrupt in 2008 in the crash, and in 2012, all of the records were sold offshore to an American pharmaceutical company, Amgen. So these are the kinds of deep concerns, I think, that we don't see when we're thinking about the sort of benign genealogist, working away in the National Archives. So let me start then with the question of data mining and ownership of records, since I think the privacy concerns really start there. So the first clip I'm going to show you is with Friedrich Skúlason, who's the founder of Íslendingabók, and that's the Iceland genealogy database. And he's talking about data mining genealogy records. You'll see then in this sequence Ron Raymer, who's an avid genealogist from Markham. Then Dan, who's one of the founders of Ancestry.com, and then Paul Nauda, who's a senior marketing manager for the LDS Church, and then Paul Allen, who's the other co-founder of Ancestry.com. So you get kind of an overview of the question of who owns the records. And they all seem a bit vague on this question, surprisingly. So can we talk about technology for a minute? I mean, the reason you have been able to create this complete database is because you've had the technology to do it.
did approach things in a slightly different way. Instead of looking for individual people and tracing their ancestry, we approached this, as I said, as a data mining operation. For example, one thing we did, we computerized entire censuses. We were not tracing the ancestry of individual people. That sort of appeared as a side effect of going through the entire mountain of data.
It's in very fragile condition, and for our purposes today, I thought this would be useful.
Data mining of aggregated records opens up a number of questions around ownership and privacy, especially for people who are simply pursuing their personal family histories.
Right there beside where the cheese factory would have been.
Should people be concerned about the privacy of the genealogical records that they upload to various sites?
I upload material to Ancestry, but I've got the setting that it's private, not seen by others. I'm hoping it's kept private.
There's a file with all the pictures of the gravestones.
I asked Ron if he's confident that files and images are deleted when requested.
Obviously, if I don't have a subscription with them anymore.
Oh. Are we losing signal? You think we just left it up too long?
I don't think so either. Do you want to keep trying to clip?
Sorry?
How much more did we need?
It's about halfway through the clip. Shall we reload it? There we go. Okay.
See if we can catch up to it.
Yeah.
Friedrich had personally entered 300,000 records in the Icelandica book database. 1,000 Icelanders. Files and images are deleted when requested.
Obviously, if I don't have a subscription with them anymore and I've deleted my tree, I'm hoping that it's deleted.
But the fine print on any genealogy or DNA site, which few people ever read, reveals a much more complex relationship between users and their donated information.
Ownership of genealogy data is at best a gray area, and it depends really on what you're talking about. The data itself, what we call the phone book for the dead, the birth dates and names and places, that's public information for the most part in the United States. But when a company goes in and adds value by aggregating a lot of data and then combining it with a retrieval system, that aggregated information, just like a phone book, becomes copyrightable.
Who owns the information? Depends on the type of record, but record custodians, obviously, are the original owners of those records.
I spoke with everybody. I said, did you know my father was Jewish? Nobody knew.
As soon as you donate that in a public forum, well, it pretty much becomes public.
My father never ever gave any hint of anything of his background, of his Jewish background. My grandmother either. He never came to church with us.
So if you want your family tree to stay just the way it is and you remember it, then you might not want to share it too freely with the internet the way it is today.
My online family tree, I think, yeah, they could probably do what they want with it, except I think there's protection for living people. I think they kind of scrub out the living relatives. But as far as I know, as soon as someone is deceased, their own personal privacy is no longer a human right, I guess you would say. And so I'm not sure there's any movement or any effort to try to protect any records that pertain to people who are no longer living.
We have multinational companies doing big business, selling people's information to them about their family members in the past. Information that maybe 50, 100 years ago people would have naturally had passed down from generation to generation. If there's a new data set that's emerged, they very much market that as the new thing that they have on offer. And it's both about selling genealogy to people as yet uninitiated, but it's also about reselling genealogy to those who might have been pursuing it but have dropped it. History is marketed all around us, whether it's in terms of the kinds of food that we're eating, whether it's in terms of the kinds of country houses that we're looking at, whether it's in terms of returning to vintage clothing on the street. So history is sold everywhere, and genealogy is just one manifestation of that. I think it's very rare that the genealogy industry as a whole really approaches the question of ethics and the ways in which family history should be dealt with sensitively, given that there's multiple stakeholders in a family history, not just the person doing the research, but the people who are being researched or who were close with the people who are now being researched. So I think there's a great deal to say about the ethics of research in genealogy.
So several issues, I think, emerge. One, that data collection happens in many ways. Government records are bought or traded for digitization services and then indexed. Organizations like Family Search and Untitled collect historical records firsthand by microfilming and then indexing and data mining. And users contribute information. And I think this is where it gets really tricky, playing a large role in aggregating the data by providing and verifying family links. And this idea of verifying family members is incredibly important because it is evidence-based. But these user trees that they upload are not necessarily, there's no guarantee that the information is necessarily correct. So there's a lot of misinformation out there as well. But the user contribution to the project is massive. So, and few users, and this is why Ron is important, and Ron is on his way to a family tree. He's got 37,000 members in his family tree right now, and he's on his way to 50,000. So he's a very experienced genealogist. He's been doing it for 40 years. He has no idea whether his records, what happens to his records once he uploads them. And the privacy settings on Ancestry.com, okay, so other people can't see your records, but presumably once you've uploaded the records, they're the proprietary right of Ancestry. So I think that he, somebody who should know better, really has very little sense of what happens to those records. Even Paul Allen, who's one of the co-founders of Ancestry, and you think who should know, isn't sure whether his own former company, which, by the way, they sold for $1.6 billion, has the right to do whatever it wants with his family tree. As he says, he doesn't think that there's any move afoot to protect the rights of the dead. So once a record has been acquired by one of these organizations, the dead have absolutely no right to privacy. Now, I mean, that despite the 100-year rule of the creation of the record or 20 years after death, but that doesn't apply to records that are uploaded by individuals, as far as I can ascertain. And it's only a small segment of what's available online. And user-generated information is very up-to-date. So who's responsible for protecting genealogists and the information that they generate? I couldn't get a very clear answer to that question from any of the industry interviews. And Anne-Marie Kramer, who's a British sociology, I think was the closest to saying, look, there are huge ethical problems with this kind of information. And of course, there's no way to regulate what the family genealogist digs up and how that information might affect other family members. So the question of de-identification that was addressed earlier in the day is an absolute oxymoron when it comes to genealogical information, because it's all about identification. And as I said, my own personal research caused decades of ongoing disagreement and tension in my family. So the larger issue, and perhaps of greater concern on the horizon, is the nature of braided genealogical information, where pedigree and genetics, and in the case of Iceland, medical records, are collected and owned by private databases. What I'll show you now is the segment on Iceland, or a segment on Iceland, which I think is the canary in the coal mine example. And here, once again, I'm speaking to Friedrich Skulason, who's the developer of Untitled. He said he was going to do it as a retirement project. It was going to take him 40 years or so. Decode Genetics came along and they said, we need that information now. And they gave him 20 people in order to create the database within 3 years.
Many people are now aware that a DNA analysis can potentially reveal one's likelihood for an illness or a disease. And Icelanders were perhaps the first to learn this, but in a manner that might serve as a cautionary tale. By 1996, Friedrich had personally entered 300,000 records in the Icelandica.
Oh, please. All right, yeah, I'll let you, it's the same as the last one, yeah. I think it just, maybe we left it up too long. Yeah, it's 3509.
There's something in all of us, some innate need.
Yeah, okay. Great, thank you.
Many people are now aware that a DNA analysis can potentially reveal one's likelihood for an illness or a disease. And Icelanders were perhaps the first to learn this, but in a manner that might serve as a cautionary tale. By 1996, Friedrich had personally entered 300,000 records in the Icelandica book database, greatly assisted by the parish records microfilmed by the Mormons in the 60s and 70s. That year, he was approached by a startup company called Decode Genetics.
I had planned to continue just adding data by myself in my spare time. I estimated it would take me 40 years or so and would complete it at the retirement home or whatever. But the people at Decode basically said, we need this database. We cannot wait 20, 30, 40 years. We need it in 2, 3, or 4 years. So, how much money do you need? Decode is interested in genetic diseases or vulnerabilities to certain diseases. We're not talking about diseases caused by a single recessive gene or something like that, nothing simple, but issues like where a particular gene or a combination of genes may increase the likelihood of getting a particular disease by 50, 60, 100% or whatever. And in order to be able to do that kind of research, they needed a database of genealogy information, and they also needed a set of genetic samples to go along with it. So they had a large number of people volunteering their genetic samples, and they got authorization from the Privacy Commission of Iceland to link those two together.
Along with genealogical records, Decode was given access to the medical records of the entire country of Iceland, and was permitted to use them in its research in a manner known as presumed consent. However, opposition to the project soon emerged. Richard Lewontin in the New York Times argued that this arrangement had transformed the entire population of Iceland into a captive biomedical community. Eventually, more than 20,000 Icelanders chose to opt out. I asked Friedrich about Icelanders' concerns.
The issues were when they wanted to link to certain types of medical history information and wanted to include information on people that were deceased and had not given their informed consent to being included in the database. 8, 16, 32, 64. That caused substantial controversy, doctor-patient privileges, and there are people that say, okay, you may discover that my grandfather was carrying some gene, and who knows, that may imply that I have a 1 in 4 chances of actually having that gene. I don't like that information to become available. I don't like my insurance company to even have the most remote chance of getting that information.
Ultimately, the initial ruling allowing Decode access to Icelanders' medical records was ruled unconstitutional, as it failed to protect personal privacy. However, in somewhat of an ironic twist, in 2012, Decode and all the Iceland records were purchased by an American pharmaceutical company called Amgen.
So, the Iceland case brings up the tension between the greater good, in the sense that Decode's research might have produced targeted drugs for particular kinds of inherited diseases, so the greater good and the privacy of the dead. Further, the Privacy Commissioner then ruled against Decode's plan to extrapolate information from the braided records in a manner that would have allowed them to deduce the DNA of the dead many, many, many generations back, and even those Icelanders who hadn't originally consented. So the ripple effects of the this braided genealogical and genetic information had some, I think, unintended consequences for people who were originally very, very enthusiastic. And Icelanders, the reason they donated their DNA in the first place was because many of them had invested in Decode as well, because they saw it as a company that was really at the cutting edge of Iceland technology, and would essentially sort of not only make a lot of money for the country, but would make a lot of money for individual shareholders. So it was all fine and good until the company went bankrupt. So I think, again, the larger issue is that these databases that are owned by private companies are subject to subject to market forces, and in the long run, we will have absolutely no control over that kind of personal information. And it is, I think, the most personal information that we're giving away in the interests of knowing ourselves better. So I think there's a real conundrum there. Thank you.